Good morning once again. Love the music there to get us ready for today's webinar. I am so excited that you could join us today, whether you are our regular guest or you are new. We wish to welcome you very much to Conversations with Wandi family. We are so excited and we always have fun. Every end of the month, every last Friday of the month, we always gather here to have conversations that enhance our HR narrative every conversation at a time. We want to emphasize that these conversations are geared to helping each one of us navigate our day-to-day lives, either personally or at work, with employees and employers, and we hope that today you're going to enjoy it as much as we do. Once again, I am Josephine Wawira. I'll be your co-host with our super host, Wandera Kweyu, who comes up with the name Wandi, just in case you're wondering. So Wandi is Wandera Kweyu, and she will be our super host today, as always. Would like to let you know that we are live on YouTube, and you can also follow updates on social media pages, that is on Twitter, Facebook, LinkedIn, and Instagram. Feel free to also update using the hashtag Conversations with Wandi, and we shall appreciate the engagement. Also, feel free to share this link with your fellow colleagues and friends who can also join, and the more, the merrier. So we look forward to this. Today we are discussing, let me just share my screen. Today, as you can see on my screen, we are discussing, or we are trying to understand the difference between an employee and a consultant. Maybe you've been wondering where you belong. Maybe where you've been wondering that you are given a contract that's saying you are a consultant. However, your roles, your responsibilities, your benefits are all the same as the other employees in the organization. And you're wondering, where do I exactly belong? Or you've also been working for more than 6 months as a consultant and you've not been given a contract and you're wondering, is this right? So we are here to answer as many questions as we can with a short presentation as usual, but we are also going to open the floor for questions and engagement. So feel free to share your questions and comments on the chats or on the Q&A section. But remember, we will also have an open discussion at the end of this discussion. So we want to have it as engaging as possible, and our super host is always the best start. So without further ado, allow me to welcome you once again, and at this juncture, welcome Wandi Wandera Kweyu to take on the floor. Karibu sana.
Thank you very much, Josephine. You could assist me by turning on my video. Thank you, everybody, for joining. If this is the first time you're joining a conversation with us, my name is Wandera Kweyu, but everybody that knows me calls me Wandi. I'm very excited and grateful for the time that you give us each and every last Friday of the month to attend this conversation. And thank you very much, Josephine, for the introduction. And I will just go straight into it once I've been able to turn on my video. Just 1 minute.
You're on now.
Thank you very much. Now, in an employment relationship, there is many things that occur. Some of them they are right, some of them they are not, some of them are governed by different areas of law. But at the end of the day, there is a premise within which an employer and employee relates that is different from how a consultant will relate with a person or an organization that is giving them business. And this is the gist of the conversation that we are planning to have today, to just have a good understanding of who then is a consultant, what is it that they are that distinguishes them from an employee. So I'll just start with the legal basis. Like I said, everything within the employment relationship has a legal basis, and the legal basis that we are referring to is the laws that are applicable in Kenya, directly in labor, and also within our constitution. So the understanding that is supposed to be very clear to everybody is that fair labor practices are expected throughout an employer-employee relationship, and even where services of an individual or an organization have been procured for their different services that they can provide to a business. So when we talk about differentiating an employee and an employer, we are not insinuating that one person should have their rights protected and their business carried out with fair labor practices and the other does not. We just mean that there's different rights and responsibilities that arise once a classification has been made as to whether this person is an employee or this person is a consultant. So where do we get this from? Now, in the Employment Act of Kenya, that is the law, in the labor law that is actually very, very much used, and quite a number of people are conversant with it. In its section 2, it has a host of descriptions on the different elements that form relationships where human capital has been procured. And one of the things that is described very clearly in that piece of legislation is who an employee is and who an employer is in section 2. The distinction, the definition is very direct and express, and that's why I say that it has an express delineation. When we say express is when you go to the law and you look for the word employer, next to it, they would give you a definition. If you go and look for the word employee, next to it, they will give you a definition. And if I could just jump right through it, an employee has been described as a person employed for wages or salaries and includes an apprentice or an indentured learner. But then the Act goes ahead and says that an employer is any person, public body, firm, corporation, or company which has entered into a contract of service to an employee to employ an individual and includes an agent, foreman, manager, or factory of such persons, public body, firm, corporation, and company. As you can tell, I'm reading, and that's like a whole list of mumbo jumbo that comes in there. So that's why today I just want to take some time to delineate this in a way that we can be able to appreciate really quickly and pick out as we are continuing in the different employment relationships that we have. Now, when we come to the word independent contractor or consultant, the interesting thing is that there is no express definition of this in any of our labor codes. And by this, I mean all the 5. There is no definition that has been given to it. However, there is a very clear definition that has been given of an independent contractor in case law. For the people that are not very familiar with the Kenyan laws, we get our laws, of course, from the written laws, the common laws of the common customs of the land, and some of the decided cases previously. And these decided cases are what we call case law. So there is a case, that has defined what an independent contractor is. And for those people who are interested, it's just a case between Duncan Nderitu Ndegwa versus Kenya Pipeline Company Limited. It was decided in 2013. There is their definition of what a consultant or an independent contractor is. The reason I mention this is so that we can be able to appreciate and understand, simply because that matter is not put in a labor code doesn't mean that it does not function as law in the country. You have to be quite clear, all the codes, and also looked at international regulation, and also put into consideration past decided cases. So in this particular situation, we have to remember two things. One, an employer and an employee, they get an express definition in the Employment Act. An independent contractor, on the other hand, has gotten their clear definition from a decided case. This case was decided in 2013, Duncan Nderitu versus Kenya Pipeline. We will be able to share these notes with you, so don't worry about it, so that you can get time and read through it if you're interested to learn more. Now, once I have explained this legal basis, at this point, it's still quite fuzzy, as in who is an employer, who is an independent contractor. So let's get into the meat of it all. Just if you could move to the next slide. Now, as you notice, the employer-employee relationship has been delineated by using the term contract of service. And if you read the act and read the laws, you see there is a differentiation between a contract of service and a contract for services. Now, this is where the first big definition starts to occur, where we start to see a difference between who an employer is, who an employee is, and who an employee is to an employer, and who an independent contractor is to an employer, right? So we get into this situation where we ask, how does an employer procure the services of an individual or a business to give services in the human capital sector, right? This is where we say they are procured through the two types of contracts: contract of service and contract for services, right? Sorry, I see I have a bit of a typo on my slide. The contract in green is supposed to be contract for services, and the first one is contract of service. Now, what is a contract of service? If we just break it down slowly, this is a contract that occurs when the relationship is of that of an employer and an employee. How do you realize it? You realize that this contract is first an agreement. The first thing I have to say for each and every individual to consistently remember, if people have not agreed on something, you cannot enforce it. Even when you're doing disciplinary procedures or running through company policies and processes, you have to ensure that an agreement has been reached between the two people, because a contract starts when somebody offers and says, oh, I'm open to give you this. This person looks at this thing and says, okay, I like this and this, so let's put this down. So that agreement is the first instance that the contract starts to happen. The agreement can either be written or oral. Now, most of the people would ask, if I have a contract and I'm working for somebody and they are paying me and they haven't put it in writing, does that mean that then I am not an employee, or does that make me a consultant? But truth of the matter is that in the Kenyan legislation, a contract of service that makes you an employee can either be in writing or oral. So it can also be implied or expressed. But the thing is, they always say that a contract should be put in writing after 3 months. And if it doesn't, it automatically is considered as a contract of service. So whether it's written or not, the definition and the rights and duties that accrue depend on how you and that individual that is you're contracted to have been operating. So whether it is implied or expressed, the thing is, it will still become a contract of service. Now, a contract of service can be a fixed term contract or an open-ended contract. I know quite a number of people have this delineation. They say if it's a fixed term contract, if it is an open-ended contract, there is a difference in how it's treated. But under the Kenyan law, this difference is really not there. The nuances behind it is that when a contract that is of a fixed term elapses, the employer has a right to not renew it. for no reason at all. That's the only difference that occurs. But if the contract has not expired, this particular employee will be treated exactly the same way as that person who has an open-ended contract, in the sense that the rights and the duties and the protections that come to that employee with an open-ended contract are the same rights and duties that come to that employee who has a fixed-term contract. Now, a contract of service, like I've been saying, is entered into by an employer and an employee. So you will start to see words like conversations with Wandi, employer, registered in this place, blah, blah, and has entered into an employment relationship with Wandi, employee. You will start seeing those words coming through in that particular contract. Now, this contract of service is governed by the provisions of the labor laws of Kenya. So you notice that the moment this contract of service comes up, there are some things that it is automatically supposed to have. Whether it has it or not is not the substance, but it is a minimum requirement that this contract of service should look like this. When we come to a contract for services, on the other hand, it is still an agreement. It is still formal in the sense that it could be written or implied in the oral performance. It is, however, entered into by a business or a company and a self-employed individual. Now that's where the distinction starts. And its guidance is found from common law practices, the Constitution, and other fair labor practices. So what you notice is that the requirements of the Employment Act, the Labor Relations Act, the Labor Institutions Act, WIBA, income tax processes that come with the employee, you would find that more often than not, these requirements are not put up for a contract for services. Now, this is the first distinction when it just comes to the contracts. So the first place you can look at is, what contract do I have? Does my contract meet all the requirements of a contract of service, or does my contract meet all the requirements of a contract for services? That is the first distinction that we need to have, right? So when we come and say that the contract for services gives you, a contract of service gives you as an employee some certain rights and duties, how do you delineate and tell this contract really is a contract of service? And please remember that I said this contract, it's either in writing or orally performed. So if you're in an employment relationship, just the next slide, and you're able to see the following rights and duties are applicable to you. Like number one, your contract has your full employee particulars, your name, your where you're coming from, PO box, all these things are there. Your pay details have been put. You've been told you're being paid this amount of money, whether it's a gross consolidated salary or if it's broken down into basic and other components, it's listed there. Then you would see the benefits that you have been put in place. What benefits are accruing? Is there medical insurance and group life cover and all these things? They are also there. You will see your contract will have a whole section that is dedicated to the management of discipline. If you would see that your contract is attached to it, there is a job description. And annexed to that contract will be a HR policy of an organization. You'd be asked, of course, to sign, to accept, and this is part of the substance of a contract. When you come to the minimum conditions that are in that contract, again, now you start seeing the relationship where the governance is of the labor codes of Kenya. You start to see your hours of work have been defined. You notice that your absence management is there. They have told you this is the leave you have annually. If you're in parental leave, you have your maternity, paternity, and pre-adoptive leave, your sick leave, and any other compassionate leave, study leaves, all these things, they have been put with the basic minimum conditions as noted in the Employment Act, right? The thing that I need to remind every employer that is here and every employee that is here to looking out for their different rights is that you can always go to the Employment Act and look to make sure that you have fulfilled the minimum. The thing about the Kenyan law is that it works with a minimalistic approach. It gives you the minimum of something that can be done, but the maximum of that something is entirely up to you. So what that means is that if the law says the minimum is 21 days of leave, You cannot give somebody 20 days of leave. That is illegal. However, you can give somebody 30 or 35 days of leave. So you will notice that that is mentioned for you. Now, housing is also mentioned in your contract. You are getting a gross consolidated salary. For those people who've not seen housing in their contract ever, it's because you notice that they give you a gross consolidated salary, meaning that all the other components that are put there in your basic include the 15% housing allowance as is noted in our laws, right? You will also see that in your workplace, you've been provided some things that are supposed to be there, like, water, lavatory, and all these other particulars. You notice that your medical attention has been taken care of either by the employer working with deducting your NHIF, or they have actually given you medical insurance, and in the workplace, they are providing you with a first aid kit among all those other areas. When it comes to your wages, when you're unemployed, when it comes to the protections that you have when you're unemployed, you will notice that one protection you have is your wages, where they have told you you will earn this amount, which will be paid on the last day of the month, or save for the taxes, right? In these wages, you will see that the employer has the responsibility to take care of the statutory implications and deductions that come from your contract. You'll notice that you have protections when it comes to issues of termination and dismissal. You will notice that you have protection in the sense that you cannot be forced to perform certain works, which is now what we call forced labor. You'll notice that there are provisions of protecting you as an employee from issues of harassment and bullying. So you would see things like a sexual harassment policy in place, a HIV and AIDS policy in place. You can see some other organizations that are actually quite progressive. They have a whole sector on just general bullying and other forms of harassment. You'd also see people championing agendas like diversity, inclusion, and equity. There's so many other protection that comes in your relationship with that employer. Again, I have to say these things can either be in writing or they can be implied. So this is the one thing that we need to remember. Simply because you don't have a written contract, if they are doing these things for you, they have performed that contract. So essentially, you become an employee. When you have a contract for services, 80% of these things are not there. What you notice is you would have your particulars as usual, you will have your fee, and you will have what it is that you're supposed to do. You will notice that the other things when it comes to protections of IP, protection for negligence, end of contract are governed like a general contract. What do I mean by a general contract? If, for instance, you're in an organization that has outsourced the provision of water to a water company, let's say CWW is a water company, and we've said CWW will provide water. Every 15th day, 20 bottles of water will be replaced consistently for every month for the next 3 years. If I'm dissatisfied with the services, either party can give a notice of say 30 days to terminate the contract. So you work with the CWW and you notice that X company there is now bringing water, but this water is like say 100 shillings cheaper per bottle, and you're thinking, this makes economic sense for me. So you write to Wandy, dear Wandy, thank you for the services. This is giving you notice that in the next 30 days we shall terminate the contract, and that's it. You pay me what is pending and we go ahead. That's the same way you deal with a consultant. So there is no termination for costs on like the way there is for an employee. The dismissal processes are just dealt with on the notice clauses on the contract. The issues of integration and other things that we'll be discussing in detail when we're talking about the tests and the other nuances between an employer and an employee and a consultant will be very clear as we continue. At this point, I would like to just ask Josephine, is there any question? Any person in the conversation that has a question, something typed on the question and answer session before we move into the detail of the tests that you can use consistently.
Thank you, Wandy. We do not have any questions at this moment, and I would want to encourage participants to feel free to send their questions either on the chat or on the Q&A section.
Great. So I just want to do a quick recap so that at this point we are all aligned on exactly what it is that we have been discussing so far. A consultant and an employee are both people that have a relationship with an employer or a company. It's the nature of the relationship that then changes, and some of the actions that are that then occur that delineate these two people. One is the legal basis. An employer and an employee are expressly defined in the Employment Act 2007 in Kenya. An independent contractor, on the other hand, has been defined in case law. This case was decided in 2013. It's a case Duncan Deritu versus Kenya Pipeline. This is where we see a first, very clear definition as to what an independent contractor is. Now, when you come to the basis of the legal basis in continuation, the type of contract that an employer enters into with an employee and the type of contract that an employer enters into with an independent contractor is different. The employer enters into a contract of service with an employee and enters into a contract for services with an independent contractor. The differences between these two contracts are based on, one, the duties, the responsibilities that occur once it has been entered into, and these duties are governed by different types of laws. The contract of services is the one that is entered into between an employer and an employee, and they are governed 100% by the minimal provisions of the labor laws in Kenya. And I mean all of the labor laws in Kenya. So here you will get your Employment Act, you will get your Labor Relations Act, Labor Institutions Act, you would get your WIBA, you would get the sections that come with the NSSF, NHIF, and all the other subsidiary legislations that come into this. So this is where you would see issues of minimum wage come up through the process, through the Labor Relations Act. You would see the regulations of trade unions, if it is in existence or otherwise, through this particular type of contract. Now, the contract for services that is entered into between an employer or a business and a self-employed person who is a consultant are not governed by that. On the other hand, they are governed by the common law principles of contract. And that's where I gave the example of a water supplier and a cheaper one comes up, and then we just properly go through our agreement and end it. So common law practices, contract law, fair labor practices also are considered in it, but not the rights and duties that arise that are minimum for an employee, all right? Now, I have just gone ahead to explain what these rights and duties of an employee are so that we remain consistently conscious of what exactly that means. Now, Josephine, you can go ahead. I see there is
before we go to the next slide, there's a question from Ann Kagali asking, an employee gets a pay slip. Should an independent contractor also get pay slips?
Again, when I talk about protection of wages, the condition that an employee should get an itemized payslip is not a compulsory notation for a consultant. An employee is the one who must get an itemized statement of pay. This is contained in the Employment Act. Consultant, on the other hand, a consultant gives a service invoice at the end of every month. This invoice is then paid. The payment receipts can be given etc, but it is not necessarily referred to as a payslip, but it could just be proof of payment. But the itemized payslip requirement, on the other hand, is that of is contained in a contract of service where an employer has entered into a relationship with an employee. Now, let's go into this some of these terminologies that are important for us to continuously remember as we are talking about an employer and an employee. First thing, the terminology of the contract is not the determinant factor. And I want everybody here to be quite alive to that particular comment that I have just made. Simply because you have written a contract and said, entered into between CWW and 1D, CWW employer, 1D consultant. And I've treated 1D exactly with all the rights, the duties, responsibilities, and subjected her to the labor laws of Kenya, the terminology of that contract will not matter. What will matter is the substance of that contract. How has this contract been performed? Persons with contracts reading consultants can be reclassified as employees. Ladies and gentlemen, this reclassification is not uncommon. Quite a number of people through legal processes have been reclassified as an employee. The risk that occurs when a person that is a consultant is reclassified as an employee is that you will then have to make sure that this individual has been given the rights, the duties, the responsibilities, and the protections that a regular employee should be given. So you need to be really careful, especially my SME and my micro SME clients in here. You have to remember that simply because you have written a contract and said consultant, that's not what will determine it all. The circumstances around the performance of that contract is key. The way this person has been dealt with in the organization is key. And a person having a contract that reads consultant can actually be reclassified as an employee. And this reclassification is not uncommon in Kenya at all. Quite a number have actually been reclassified. So simply because you have a contract that says consultant, it doesn't preclude you from having that person reclassified as an employee, especially when you as an employer are treating that person with the rights, the duties, the responsibilities, and protections of an employee. So what I'm trying to say here, you can't pick and choose. Simply because you're saying, when I put this amount and then I add the taxes, it's really high. So let's say consultant. That doesn't mean then that you're now free, you can deal with them in common law practices and not follow the rights that are accruing from the labor codes. This is something that I need every person in this process to keep remembering as we are proceeding. Simply because you have put it in that terminology doesn't mean that that would be the be all and say all of that contract in the event that a dispute arises. Now, how will we then know if I have a contract that reads employee, this one reads employer? How will I then know how to differentiate the two? All right. So just when you can go into the next slide. Now, I will be recapping just again to make sure that we are following. One, the employer, employee, employer, independent contractor and or consultant relationship has a legal basis in Kenya. When we come to definitions, the Employment Act has expressly defined 1, an employer, 2, an employee. The express definitions are there in the Employment Act section 2. The independent contractor and or the consultant has been defined in a decided case. This case is Duncan Deritu versus Kenya Pipeline. It was decided in 2013. If you're interested, you can go read about it. This is where we get the pure definition of who an independent contractor is. Once we have seen these definitions, this type of procurement of their services within the law occurs in this way. An employer enters into a contract of services with an employee. An employer enters into a contract for services with an independent contractor or a consultant, right? The contract of service, it could be written, it could be oral, implied, express, termed, or open-ended, entered into employer, employee. That's where you see in the contract, those terminologies start coming, and they are governed by the labor laws of Kenya. So you will see some minimum rights and duties occur, and they have to be respected from the way, from the contents of the contract, where there's the particulars, the pay, the benefits, the job description and attachments to the HR policy, discipline management, etc. Those things must be in the contract. You will see protections coming in when it comes to wages, sexual harassment, HIV and AIDS, and general discrimination. You will see protection when it comes to dismissal and termination and just the general handling of that employee. Now, for the contract of services for services on the other hand, it could be, it is formal, written or oral, but performed in a certain way. It is now entered between a company, a business, an employer, and an independent contractor. And then this contract is governed by common law practices and fair labor practices. So you don't find the rights and duties arising from our labor codes in this particular type of contract. We go further and mention, simply because you have put a terminology and said this is a contract for service, this Wandi is an employee, is an independent contractor, that doesn't preclude you from being reclassified as an employee. What will matter is the substance of your contract. How have you treated this person as we have been working with them? This is now where we come into, what are the tests? How do we know that this person is indeed a consultant or an employee, irrespective of the terminologies of their contract, right? I hope up to here everybody is following. Now, there's been very many conversations on who can be a contract, who is an independent contractor, who is an employee. But when you come to the legal process in Kenya, there are some certain tests that are used consistently to determine an employer's relationship with an employee, an employer's relationship with an independent contractor. And these tests are the 4 tests that are currently on my screen. I will go into detail and discuss one after the other. Number 1 is the control test. The question here is, the courts always wonder to what extent is a person under the direction or the control of that company? To what extent? Are their hours of work very much defined by the employer? Is their place of work defined by the employer? Is how the work is done defined by the employer? The longer the control, the more the control by the employer, the more that person is an employee. This is how you will notice, for instance, most of these independent contractors, they don't even work from the office. They don't keep the same time as the employees keep the same time in the office. You find that the integration, the way they are controlled by the employer, mainly other than specifically, let's say, we've agreed that this is the scope of work. It's very difficult for you to say, if you didn't do 40 hours, I can do for you a disciplinary case. If you didn't show up on Tuesday, the point is we need this work done in this time and this is the fee. But when it comes to an employee, on the other hand, the controls are there, the controls are a lot, and they are clearly determined. That's the first test that you use, yeah? The second test is the test of integration. How have you integrated this person into the organization? So fine, you have this person says employee, this person says consultant. This person can work from home. This person has to follow the controls of the organization, right? And then you notice that the difference starts becoming a little bit more murky, in the sense that both these people also work under the same HR policy. Both these people are getting all the benefits that are accruing throughout the organization. If this person who is the so-called consultant does something that is out of the ordinary, you notice that they are subjected to the disciplinary process of the organization. Ladies and gentlemen, at this point, this consultant is an employee. We have to really know that not all the tests need to be there, but some of the tests can be there, all of the tests can be positive, but this substance is what will differentiate these persons from being one and the same, sorry. So for instance, if a consultant has done something out of the ordinary, normally you treat it the way you treat a normal contract. If this is something that is agreeable, you can discuss it and have a meeting and tell this person, okay, could we do this way and this way and this way? We agree, we move forward, great. If we don't, we give them notice and say, okay, now this is not working for us, following the notice, blah, blah, let's conclude it. But when it comes to an employee, on the other hand, you cannot do that. You have to do the show cause letter, move ahead with the disciplinary process, etc. up until when this person is lawfully terminated. The next case, the test that you can look at is the economic test. I personally like this test very much because it's the one that gives me light bulb. This is an employer, this is an employee. The question is, ask yourself, ultimately, who is responsible for the profit and loss of the business? Ultimately, who is responsible for it? If, for instance, my business fails, as an employee, I will get my redundancy pay, etc., and go away, right? The duties that are arising between myself as the employer with my other people, etc., that one has nothing to do with the employee. If at the end of a financial year, a company makes a profit of say 20 million or a loss of the same amount, the employee really has no ultimate responsibility in that. The employee can facilitate the creation of that profit and or loss, but the ultimate responsibility remains with the company. Now, a contractor, on the other hand, has the exact same responsibility as a company. If I don't make a profit, for me, as an independent contractor, my business has made a loss, because my business is that of a consultancy. Simply because the business made a loss, the company that I'm working for the company that I'm working for as a consultant made a loss, and me, I made a profit from the other employers that I've been having. You see, at the end of the day, we have different profit and loss margins, but at the end of the day, we all have profit and loss responsibility. Employees cannot be having the ultimate responsibilities of profit and or loss. But an independent consultant, they will have it because they are self-employed. The last test that is normally very clear is the mutual obligations test. I also love this one. Yeah? The question then comes in, what mutual obligations have existed between these two individuals that have contracted, have been procured for services into an organization? With an employment relationship, what you will start noticing is there is, you're supposed to do this, you're supposed to perform it to this level, and it can continue to this length, and then will continue in perpetuity of the business. You see, there's an obligation that has been put here, there's raised there, and we are continuing. A contractual relationship between an independent contractor and an organization, on the other hand, the mutuality is not as much as that with an employee. It's normally you need to be able to do this particular issue, finish it at this time, and then we stop. Or you can do it for this particular situation, and this is the only part of the service that we will do. You'll also notice some of the obligations that arise from the two are quite significantly different. Like, for instance, when you say that I will give you pension, this does not happen in this other part of the relationship. That mutuality doesn't exist. It's just, I have come into business with another business entity, we've done our business and we are done. The mutuality when it comes to an employer and an employee is entirely different from that of an independent contractor and an employer and or a business. Up until at this point, Josephine, do we have questions?
Yes, we do have questions. We have one on the chat from Beatrice Gay, Asante Sana Beatrice. She's asking, in your perspective, what would you say are the pros and cons of being one an employee and the other a consultant? I think some of this you've already addressed, but if there is anything that you've missed to mention, maybe you can add it at this point.
For me, I would want to answer that question slightly differently. And Beatrice, thank you for your question. A business, what you need to be able to appreciate is that when you're having a consultant, you have to treat them 100% like a consultant. You will lose the control that you have over that individual. You can't necessarily deal with their hours. You can't necessarily deal with their especially exclusivity. They can have as many employers as possible. So that control that you normally have and that quality of service that you would get might not be the same especially when you are fact-checking the quality of service when you are working with an independent contractor. On the other hand, the people who genuinely hire consultants, and this one I have to be very clear, genuinely hire consultants, because there is those employers that want to use this to escape the extra cost that comes with taxation of an employee. But when you have a genuine consultant, you are actually having your business acquire some skills that are not currently present in your organization. So if you're a recruiter, for instance, and you're a person who's doing organizational development and learning, and you know that people procure services in 3 ways. You can either build, buy, or borrow, right? So the borrowing is where you're getting a consultant to come and do for you something as the people in the organization are learning from that individual. The beauty of having an employee is, one, your succession of the business becomes more secure, and the structure of your business consistently supports its future growth and continuity of the business. With consultants, they can up and leave any particular time, same as employees, but then the mutual obligations between the two are significantly different when it comes to those items that I have mentioned. So when you're asking pros and cons of an employer or an employee, I would want you to appreciate which side of the divide are you standing. Are you the person requiring the service, or are you the person giving the services? If you want to be an employee, please, you are very protected in how it is that you are doing your work. There is a high chance of security, especially simply because you are not responsible for the economic loss and or gain of that business. You get a secure payslip and you go through it. When you are a consultant, you are here, you are an entrepreneur. There are very many things that happen when that particular situation occurs. So again, look at where you're coming from, then make your decision.
Awesome. We have Mwangi asking, would you please go over the mutual obligation test again? Perhaps you can, would you want to do that now or at the end?
Going through the mutual obligations test. Let me see if I can figure out how to quickly summarize, because just when I can hear you call me out on time. So here, there is a consideration whether or not the parties make commitments to maintain the employment relationship over a period of time. This is where the mutuality comes in, right? An employment contract entails service in return for wages. And secondly, mutual promises are made for future performance, okay? This agreement, in essence, creates a sense of stability between these parties. Like you would see some of these obligations come in through, like now we've procured for you medical insurance, I've insured your life, I have gone ahead and protected you from any accidents that occur, I have given you a pension. As in, see, these mutual obligations are there. And then because I like the benefits that you're giving me, the proposition you're giving me as an employee is really good and I really want to stay in it. The obligations that occur for independent consultant, on the other hand, are not that. The mutuality here is you have the expertise I need for this particular issue. I will bring you in to conclude for me this particular issue, and I will say, thank you very much, here is your fees, have a lovely day, I might call you another time. That is the biggest difference when it comes to the mutual obligations.
All right, one last one, and then we go a marathon until the end, and then we take questions at the end. From Veronica Kaleche, you're saying, I joined in late, but I have staff that work for us from an outsourcing company. They are known as contractors in our system. They, however, are treated as employees in theory. They have sitting space, phones, laptops, medical cover. Their pay is invoiced by the outsourcing company, but I am the one who sorts out their HR needs, grievances, etc. Are we doing this right?
That's a very good question. First things first, you're not dealing with independent contractors here, you're dealing with seconded employees. Secondment is quite common in quite a number of organizations, especially in manufacturing, business processing, and these high turnover jobs. You can outsource that service to a company to give you the employees to work with you consistently. The thing that you need to remember here, Kalechi, and thank you for your question, is who is the employer? the thing that you need to protect against is you being reclassified as the employer of those people, because the contract of these people that you are in your organization, I'm 100% sure, are between themselves and the company that you have procured these services from. So try as much as possible to not be the employer. Like for instance, when they give you, at the end of the month, make sure that you pay the company for the company to pay them. Make sure that that company is the one remitting their taxes to KRA and other statutory bodies. When you're coming into disciplinary processes, it's always very important to have a representative of that outsourced company in the disciplinary hearing and chairing it as the employer, so that you don't fall into this situation where you are reclassified as the employer. But what you're dealing with is not a situation of independent contractor and employee. It's a situation of your employee and a seconded employee. All right. Now, when we come into the other useful distinctions, it's important, after you've gone through all these tests, to pick out some things that you can use to quickly tick box and say, yes, I have put this right, I have put this right. Yeah. For an employee, the salary of this employee will give you the following obligations. You will pay the pay-as-you-earn tax. You will pay NSSF. You will pay NHIF. When you are doing these things, the chances are that you are dealing with an employee, right? You will notice that other deductions to their pay are governed by law. You can't deduct anything on their pay up and this amount, etc., etc. You have the right to withhold some of their money, but not to certain amounts, right? But when it comes to a consultant, on the other hand, they will be giving you a service invoice, and there is a fees to it. Your obligation as that employer in this particular situation is to withhold tax as per government regulations and remit them, and this consultant will go and deal with their tax obligations at the end of their performance period. The thing that you have to realize that it's very difficult for you to withhold the fees of a consultant unless the consultant has not performed service. All right, so that obligation, that distinction is really good to consistently have. When an employer is working with an employee, the negligence of that employee becomes the negligence of that employer. On the other hand, an employer working with a consultant, the negligence of the consultant is the consultant's negligence, and the employer can actually be 100% indemnified from that particular situation, as in they are covered from that particular situation. As much as vicarious liability can occur in certain circumstances where somebody is now an employee, with an independent contractor, it is very clear. You take care of your duties, you take care of how you're performing your duties, and make sure that they're not performed in any neglectful way. And the employer is not responsible for any neglect that is occasioned from how the independent contractor does work. But the employee, on the other hand, the negligence of that employee becomes the negligence of the employer. And for progressive employers in this place, in this conversation right now, you notice that an employer then will start to take some certain, will assess the risks and start to put some mitigating factors in it, where you'd see an employer, for instance, buy an employer liability insurance, among other kinds of things, because the negligence of the employee is the negligence of the employer. The other thing that we need to notice is that the freedom of association is 100% on the employee only. So you see, you can't get an independent contractor who is in a union and asks the union to come into your organization to get recognized and have their processes and procedures followed, because an independent contractor does not have that luxury, because they are a business. But an employee, on the other hand, has the right to form, enter into, and cause for the union to be recognized in an organization, and the organization to work with it. At termination, this is a really good point to remember, an employee receives terminal dues in a prescribed manner. So this manner is really clear, whether it is summary dismissal, whether it is dismissal with notice, whether it is a redundancy, these things are clear. When it comes to a consultant, what is written in their contract is eaten. So I give you notice and I pay you for whatever service you've done for me. End of story. There's no other prescription. What is in the contract is what takes place. Yeah. The other big interesting place is that an employee can sue for wrongful termination. An independent contractor cannot. So if an independent contractor wants to say you wrongfully terminated me, they will be asked one question, but are you an employee? If you are not an employee of that company, you have other recourse in common law and contract law to go and to negotiate and speak, use your rights in a proper manner other than in the Employment and Labor Relations Court. Because now you have to go and say, this person is an employee, hence suing for wrongful termination. Or as an independent consultant, I'm saying that this contract was terminated unfairly. Then this process can be dealt with differently under common law and the laws of contract. But wrongful termination as per the Employment Act is not an option that is available to an independent contractor and unlike an employee. So, ladies and gentlemen, I know I have said very many things, and we just wanted to spare a good time to have quick discussions on the different matters that we have discussed. I just want to do a quick recap so that you can consistently remember what we have been talking about. Number one, the basis of a relationship of an employer and an employee, an employer and an independent contractor is founded in law. The definitions of an employer and an employee are found in the Employment Act, they are express. The definition of an independent contractor, on the other hand, has been defined in case law. The type of contract that an employer enters into with an employee is a contract of service. This contract is formal, it's written, or oral, it's fixed term or open-ended, it's implied, express. It is governed by the laws, the labor laws of Kenya. It has rights and responsibilities that are contained in the labor laws of Kenya. The common ones are, of course, your Employment Act, Labor Relations Act, Labor Institutions Act. You have WIBA, NHIF, NSSF, and all the other things that are accruing from those laws and their subsidiaries. The contract for services, which on the other hand is a contract that an employer enters into with a consultant. Yes, it is formal. Yes, it could be written or oral. It could be of a small term, or the length of the contract could be mentioned. However, this contract is governed by common law, laws of contract, and fair labor practices. So all these other rights and responsibilities that occur in terms of pay, absence, leave, and all these things don't arise in this other particular contract. When you're working with these contracts, you need to remember, one, simply because you have a contract that says this is a consultant, this is an employee, that is not how this is determined in case of a dispute. The substance of your contract becomes what determines whether or not that person is an employee or they are a consultant. When you come into the substance of the contract, there are some tests that a court of law will use to be able to tell whether or not this person is a consultant or an employee. The common tests are the control test, the integration test, the economic test, and the mutual obligation test that comes up with when they are determining such cases. I have just also gone ahead and given you some other pointers that can help you to quickly tell whether or not this person should be treated is an employee or an independent contractor as per the laws of Kenya. So issues of how they pay their taxes, the benefits that they have, issues on how you can terminate their contracts and the terminal dues that come from that, issues on their ability to associate, and also issues on whether or not they are able to sue for wrongful termination. So at this point, I would like to take questions and see if we could have a really good engaging discussion for the remaining time.
Thank you very much, Wandera, for keeping time to allow, ample period of discussion and engagement. I'm liking the questions from the chats and the Q&A. So just help you through this so that we can handle as many as possible within the less than 30 minutes remaining, because we intend to keep time to allow everybody to engage with their other, engagements. Plus, it's Friday, so it's weekend. We do not want to keep people waiting, and maybe they have early plans. So I will start this session with Fortunatus Otieno, interesting name. He's asking, what's the standard notice period to be given to a consultant?
If you look at common law practices and the laws of contractor, the notice is really a discussion. But when I see practice, I'm seeing very few have less than 30 days. And very few have more than 90 days. So it normally oscillates between 30 and 90, depending on the size of the contract and especially the delicacy of what is being delivered in the contract, the amounts payable or otherwise in the contract. Those are some of the things that determine the length of notice. But in practice, between 30 and 90 days is quite common.
Awesome. And are there similarities between a part-time employee, not clearly defined by EA though, and a consultant? Not sure what EA in this context means, but that is from Anthony Gathogo.
So I think Anthony is talking about the Employment Act.
All right.
Yes, when we are talking about a part-time employee, I would then again go back to ask you, what do you mean by a part-time employee? Do you mean that this person has is working only, let's say, on a Tuesday, Wednesday, and on a Thursday? Or are they on a roster where they only work a certain day and then they rest the other day? There are quite a number of reasons why you would have a part-time employee. However, the fact that you know they are an employee means that you need to be able to treat them with the right and responsibilities of an employee. The thing about part-time workers that I normally find to be a bit difficult is how then to delineate the benefits that accrue to them. Because I've not seen a part in law where it says we can prorate, for instance, minimum wage for a part-time employee differently from an employer, from a full-time employee. There's a bit of a push and pull there. I'd be like, if an employee is needed on a part-time basis, you're better off giving them a shorter contract. You know, like when you look at the Employment Act where it says they give you maybe a daily contract, a monthly contract for your services, etc., but don't just give them the full employment contract.
Awesome. And should a consultant be issued with a certificate of service? That is from Victoria Wambui. Just before you respond, I would want to inform that you can also, raise your hand and we will allow you to ask your question in voice. But just ensure that your connection is stable enough so that we have that question directly. So from Victoria Wambui, should a consultant be issued with a certificate of service?
Absolutely not. A certificate of service is a pre-serve of an employee, and it only occurs in the situation where a contract of services has been entered into between an employer and an employee. However, if a consultant wants to have proof that they were consulting for you, you can give them a recommendation letter or an acknowledgement that they worked for you, but not necessarily a certificate of service. It doesn't work like that for an employer. Sorry, for a contractor.
Yeah, I think I've also learned that from here. Very informative. And Eve Washira also agreed that this is a very informative session. And thanks, Wandi. Veronica Kaleche is saying, thank you, Wandi, for the answer. Karibu sana. Glory Mugambi, how does a consultant differ from a temporary employee? So the specific part here is the temporary part.
Yeah, so a temporary employee is governed again by the Employment Act. So you would see that either some of them could be casual workers, some of them could be working over a week, a month, or a specified period. Those ones are governed under the Employment Act. But a consultant, on the other hand, is not governed under the contract of for a contract of service. Because the thing you need to remember is, if you're hiring somebody temporarily as an employee, at that temporal period, they are supposed to be treated exactly like an employee. If you're hiring a consultant for a two-month period, on the other hand, they are not supposed to be treated like an employee. So this then means when you are working with a temporary employee, they have to pass the control test, the integration test, the economic test, and the mutual obligation test. If all these tests show them as an employee, treat them as an employee. If, on the other hand, they work for more than one person, you don't pay taxes for them, you don't put them into the company policies, procedures, etc., that person is a consultant, not a temporary worker.
Right. We are switching now to the Q&A section. We have a question from anonymous attendee. This means we don't have their names, but thank you. In discipline management, if an employee is sick or he has or he goes to herbalist, interesting, and not hospital because he has no money, how do you handle that?
Oh, wow, that's an interesting thing. First things first, I always like to remind employers that you have the responsibility to provide your employee with medical services and medical attention. That is the law. So please, let's just always consistently be clear on that. The reason why most of the time you notice that employers are precluded from activating this is because there is an exception to that particular rule that says you can, if there is any other government registered scheme or there's a provision of free medical services by the government, then the employer is precluded from that. So in this case, we normally mean NHIF, the situation. However, when you read the Employment Act, when it comes to issues of sick leave, it is extremely clear. It actually says you need to be able to provide documentation from an accredited doctor. It's not a medical practitioner. So for me, I would want to ask you, is herbalist the people that we look at as qualified medical practitioners? I would think not. However, I would want to ask you to wonder, because these sessions with Conversations with Wendy are not just about the legality of it all. It's also about putting the human face in an interaction. I would want you to go back and wonder, why is your employee acting this way? What is the problem that is causing them to get to this position? Is it really true that they don't have the money to be able to access better services? And can the organization figure out how they can be able to keep the health of the employee with the circumstances that are surrounding them? So for me, I wouldn't say this is necessarily a legal question alone. It's just that you have to put the legal practices and principles, but also try to put the human face back into it. So no, a prescribed doctor is not a herbalist, and no, an employer should be able to provide medical attention to their employees.
Great. And then we have, is IL-4 still applicable for laying an employee on redundancy?
Absolutely. Absolutely.
Right, Diana, I'll come back to you, but after Wendy answers this one.
Absolutely. LIFO is last in, first out. It's a principle that is used to in the process of redundancy. This is the sense that when you're declaring a redundancy, the employees that came in last should be the people that are considered for redundancy first. But this only occurs when a redundancy is happening in the same position. The thing that I need to remind employers in this room is that redundancy is a really different topic that we want to discuss in detail, but redundancy is to a position and not to a person. So in a situation where a position has been declared redundant and that position has more than one position holder, one of the principles that is used to decide which position holder will be declared redundant is when they come into the organization. That's when the principle of LIFO comes in, last in, first out. However, whoever asked that question, I would just want to invite you to our next sessions where we're talking about redundancy, because it's a whole topic that we need to discuss.
Great. At this point, Diana, you're allowed to talk. Could you please ask your question away?
Good morning, everyone.
Good morning.
I was asking, Wendy mentioned that provision of medical through NHIF, it is in order, but some people argue that provision of WIBA to the staff, that is part of medical. Maybe you can clarify that.
Okay, so I'll just use this in definition of the acts themselves, yeah, because these are two acts in place. Yeah? One act is National Health Insurance Fund. Before it used to be called National Hospital Insurance Fund. I hope you are all aware of the changes that have occurred in the NHIF section. So now it's called the National Health Insurance Fund. This other one is the Workers' Injury Benefit Act. Just in the definition, you can see the difference. One is dealing with injuries that one has suffered during work, and the other one is dealing with the provision of medical cover. How I would look at it in this particular situation, Diana, is to just appreciate that one, a person can be sick without necessarily having incurred an injury in their course of work. If I wake up and I have a cold, I need to go to the doctor. I cannot go and claim WIBA. So you have to go ahead and protect and give me the ability to get medical attention. You get my meaning? WIBA only comes into play when there has been an injury within the workplace, but it is not a medical insurance and should not be treated as such. And it wasn't in fact intended to be treated as such.
Thank you, Diana. I hope the answer is clear. We also have a question or a raised hand from Victoria Wambui. Please unmute to ask the question. Victoria? All right, maybe as she sorts that out, we can have the next question. If an employee who is a salesperson does not bring any client for a year and so, can you terminate even though you don't have any PIP, training, etc. to prove you done or you can?
I like that question. Again, this goes back into discipline management and termination, a whole issue that we need to discuss, but you need to consistently show that you actually dismissed somebody for cause. When you're dealing with issues of performance, please be consistent with documenting the lack of performance. This employee should be dismissed for cause because they are unable to meet their processes, but it is good for you to have had PIPs, etc. However, when it has occurred and you need to be able to go through the process, it is important that you now start to document, give them a short course and be like, okay, you joined the organization on this date, you've consistently not met your targets. If you are giving targets letters, it's good to now use them here. This was your target, this was your records, always below par. Your managers have spoken to you, there's been no improvement. Give us a reason as to why disciplinary action should not be taken against you. And then you go into the process and complete it. That doesn't make it an illegal process. It's just that showing that you put some effort into it adds the human face into the conversation, and this is what actually the courts would prefer to see on a regular basis rather than when you just up and remove an individual. The process can be done, but it is more humane if you had gone through the processes of PIP and performance mentioning.
All right. I just wanted to clarify. I'm just comparing the Q&As and the chats. That leave for question had come from Jacinta Kisungi, Asante Sana, and Diana Karikabiru is also saying that the difference between the NHIF and the WIBA medical cover is clear, and she appreciates that. Victoria, are you now able to ask your question, or do we go to the next one? Victoria?
Morning, Wendy.
Morning.
Sorry for the background noise. Not a question, but maybe a suggestion. Can we have a discussion between the difference between termination and summary dismissal?
Yeah, yes, this is something that we can discuss just when we can take note for future webinars.
Okay, thank you.
Thank you very much, Victoria.
Asante Sana, we are always welcome to hearing suggestions, because remember, our conversations are monthly and therefore we need as many conversations as possible. This is not quarterly or yearly, it's monthly, and therefore any topic that you feel will be relevant for you and your organization is always welcome. So yes, we have taken note of that, and we shall prepare that for the coming webinars. Also remember, if you feel that you want to have these conversations for your team specifically, you can always reach out to us via info@conversationswithwandy.org. org, and we can organize for a session with your team so that they are able to ask all the questions regarding that topic and more. And Beatrice Gay is saying, much appreciated, Wandi. You delivered this in a very simple way. Always love your sessions. Asante sana. We have another question from Diana. When the contract lapses automatically by end of time, is it mandatory for the employee to take the contract break and utilize all the leave days before renewal is done?
That's interesting. That's a very interesting question, because why not just renew the contract and continue? Because if you renew the contract, it's more interesting for you to continue with the relationships rather than pausing it. And for me, pausing a relationship, if you're doing that to avoid paying for the leave days, that is illegal. I have to be very clear about that. I'm just trying to understand why an employer would do that. Because if you tell somebody, go on leave until you complete your leave days before your contract ends, then I can renew other one. You're saying you're putting them on administrative leave, which is not supposed to be the case. If a contract still has leave in the process and it has lapsed, you need to pay for that leave. If you don't want to pay for that leave and you know very well that you're going to extend the contract, just extend the contract and continue with it. But what you need to be able to do is manage the fact that people should utilize leave, because leave is very important for people to just rest and rejuvenate. But please don't use go and finish your leave days before your contract ends as a way to make sure that you are reducing your business costs, because that's not the proper way to do it.
Sawa Diana, feels like you might need a special session for you and your team, so always feel free to reach out to us. We have a follow-up question on WIBA. Sorry, but when an employee is injured and all medical bills paid by the company and all his salary paid, including the time he stayed home to heal, is the insurance supposed to pay the company back, and what is the procedure? So I don't know if we should have, sorry?
Say again that question. I missed you at the last part.
All right, it's a follow-up on WIBA, and it may be we should have also a session on this one, because it always seems not so clear to many people. And this person is asking, when an employee is injured and all medical bills paid by the company and all his salary paid, including the time he stayed home to heal, is the insurance supposed to pay the company back, and what is the procedure?
Oh yeah, you're very right. This is a whole conversation that we need to have on just the general occupational hazards and how we deal with them, and filling forms for WIBA claims. There's a whole process on it. There is a form that you're supposed to fill. There is levels of injuries that are supposed to be mentioned. It depends on the kind of, the extent to which your insurance, your WIBA cover works, and to what levels the WIBA cover will be able to reimburse, and to what positions this cover is in existence. So for me, I would request if that the person that has asked that question to either be patient to the date we will get to discussing WIBA, or we can have a separate session with them to just quickly go through WIBA, because that's it's a whole process.
All right, so just to clarify a bit, so our webinars, our monthly webinars are completely free at no fee. However, our individual engagements are at a fee, but do not get scared at that, because you will have so many benefits by having a personalized conversation, because all that time is going to only be dedicated to you, and you also get, to go away with as many clarifications as possible on this specific topic. So I just wanted to make that one clear. And then there's one question: what's the maximum number of times a probation period can be extended?
A probation period should not last for more than a year. Somebody should not be on probation for more than a year. So you can extend it many times throughout the process, but the maximum length of time is a year. However, for me, if the probation has been extended the first time, the second time, then that's not the person that you are looking for. Overextending probation is also quite psychologically traumatizing for the employee. We have to really consider that. So for me, I would say to this person, have that difficult conversation, yeah? just be able to tell the person, okay, so this is where you're not meeting what we're requiring. This is the interventions that we can put in place to make sure that you're able to do X, Y, Z, support them through that process. And if they are not able, just keep letting them know in advance that, hey, you're not meeting, we're trying, you're not meeting, so that you just start a disciplinary process and go through dismissal. But the thing is, 12 months is the maximum length of time. So within those, 12 months, you can be able to do as many extensions as possible, but that's not very humane. And also practice, you see, if a person is on a 3-month probation period, it's normally extended for another 3 months. If one is on a 6-month probation period, it's extended for another 6 months. So you can't say that I've extended it for 2 weeks, I've extended it for 1 week. Also, just go with commonly accepted practices while you're doing this.
Great. I do not see, okay, there's one. Okay, thanks for the feedback on extension of probation, Karibu Sana. I do not see any other question or hand raised. What we have is from Diana. Maybe you can lower your hand unless you have another question. Oh, we have Ann Muguna. Can a consultant be transferred from one subsidiary company to another? Before you answer, I just want to give a special thanks to those who are engaging us on social media. Please remember, you can still do so now and even after the webinar on tagging or hashtagging Conversations with Wandi and employee versus consultant. We really, really appreciate that engagement. Wandi, can a consultant be transferred from one subsidiary company to another?
Yes, it can work. If the expertise of that person is needed in the subsidiary, then why not? But please remember, just go through the tests again. The control test, the integration test, the economic test, the mutual obligation test. Do this person really stand as a consultant? And if they do, then we just go through the normal process of contractual agreement, and they can say, okay, so thank you, you gave services to this particular subsidiary. Now we will take you to provide the same services in the next subsidiary. There's absolutely nothing wrong with that. The only key is to make sure that this person is actually a consultant and it's not an employee disguised as a consultant.
Amazing conversation with Wandi. Much appreciating today's session. It's been a bomb. It's been engaging. It's been educative. Mutisia Maingi, can an employee be both employed and a consultant within the same organization? Interesting question there.
No. That's a very thin line, eh? Because then how will you separate there? That's a very thin line. I don't see how practically that can work, because if you're already an employee, will you stop your employment to do the consultancy, or will you be running the consultancy with the employee? That's a very difficult situation in practice. I'm not sure I've seen that happening in practice at all. And also it's very risky, because then how will you say you have transited that employee into consultant and then transited them back into employee? How can you practically do that and within the law? So for me, I would say don't go in that direction. If a person wants to be a consultant, they should just be a consultant. If they are an employee, let them just be an employee, but they can't be both.
All right. Can you reduce an employee to a consultant if no work, if there's no more work to be done?
Can you do what?
Can you reduce an employee to a consultant if there's no more work to be done?
If there's no more work to be done, that's an area of redundancy. You need to declare a redundancy and not change a contract. So declare a redundancy and go through the process of a redundancy.
Great. We hope we've been able to respond to all your questions at this juncture. We are just a few minutes to 10:30, which is our ending time. We appreciate the engagement, and it's amazing that more questions are still coming in. We appreciate that. Just in case you have a question and we run out of time before we respond to that, please, you can still ask that on our social media handles. That is on Twitter, Facebook, LinkedIn, and Instagram. Remember to hashtag Conversations with Wandi and hashtag employee versus consultant, and we are going to respond. You can also email us at info@conversationswithwandi.org. But just before we close this session, we have, let's just respond to this one last question from Millicent Andayi. Oh gosh. Can a casual worker get a longer contract, like for 6 months, when they are being paid by an hourly rate?
The moment 90 days happen when a person is a casual worker, on the 91st day, they become an employee. So they can't get a 6-month contract. Instead, why don't you just give that person a temporary contract of 6 months, so that when it finishes, they can just leave the organization. But don't call them a casual worker, because that is not a casual worker. That is an employee. Remember the test, 90 plus 1. On the 91st day, employee.
And is it a good idea to promote a consultant to a full-time employee? From Albert Chillard.
From who?
Albert Chillard.
Oh yeah, Albert, that's actually a really good thing. And I've seen quite a number of consultants get employment contracts. The thing that you need to be able to consistently remember is when you're doing that changeover, issue this person with a new contract, with new terms, as in now transition them from the contract for services into the contract of service. Make sure you give them the contract, integrate them into the organization, and now continuously just fulfill your obligations as an employer to that particular employee. But this is what
I promise this is the very last one. So Wendy, as you respond to this, also give your closing remarks, because I'm very conscious about time. We have 2 minutes. And the question is, if a project is stalled due to client's fault, but the employee is a requirement in the contract signed by the client, signed with the client. I don't know whether what the question is here, or should it be if to end the contract or the engagement? Or is it legal to keep on issuing 3 months based on clients' extensions?
As long as it's a term contract where you told somebody your contract is for 3 months, you can continue extending it or end it once the period has lapsed. But just make sure you don't give an open-ended contract, because the moment you give an open-ended contract, then it becomes really difficult for you to end the contract, because then it has to be with cause. But if it's a term contract, you can keep issuing. But when you're doing this particular issue, you need to also talk to your employees. Again, keep remembering that it's not just about the legalities. You're dealing with a human being here. You need to be able to speak with these people and consistently appraise them on where the situation is with the client and what the chances are for them, and just keep them in a good headspace to want to continue to work with you as you're dealing with the issues and the challenges with the client. Just ensure it's not an open-ended contract. And I see, Josephine, we're 1 minute to the mid of the hour. At this particular point, I just want to say I am so grateful for the amazing questions that have come in. This has been a very interesting and engaging session. You can always, as Josephine has said, reach out to us on info@conversationswithwandy.org. You can always follow us on our handles and on our socials. That's LinkedIn, Twitter, Facebook, Instagram, and YouTube. You can also watch our previous webinars on YouTube, and we just really look forward to having you in the next month, same time, same place. Thank you very much, and back to you, Josephine.
All right, people, it's a wrap. We hope you enjoyed this as much as we did. One of our greatest mottos is that we are going to have conversations that enhance our HR engagements with all of you, and we wouldn't have done this without you. We wouldn't have done this if you didn't show up. So a big thank you, and see you next time. Remember, once again, I'll be looking out for your tweets and your posts on LinkedIn, on Facebook, on Twitter, and on Instagram. Asanteni sana. Have a lovely day. Have a lovely weekend. Bye-bye.
Thank you. Bye.